thank you for joining us. My name is Katie Perez, and I'm a senior associate at Scott Legal PC. Today, we're going to spend some time talking about the employment-based green card categories and many other questions that often come up when people are in the green card process. So just a few things before we get started. Some of you may know that our firm was founded on an E-2 visa several years ago. Our founder, Ian Scott, is in the U.S. on an E-2 visa and has been on several different visas, including an F-1, a TN, B, and the H-1B. Scott Legal PC is a full-service immigration law firm, and we offer immigration services in several different areas, including the E-2, E-1, TN, L-1 family immigration, national interest waivers, EB-5 extraordinary ability visas, and more. So we will continue this webinar series, doing at least 2 webinars a week on different topics. At the end of this webinar, we will send out several useful tools. We will send you a copy of the PowerPoint presentation from today, a link where you can download guides that go through the visa options in more detail, and also a link where you can sign up for additional webinars. This webinar will be recorded and available on YouTube. We'll also send the link for that. We encourage you to subscribe and to hit the notification buttons as we regularly upload immigration videos on a wide variety of topics. We'll also send you a link where you can arrange a consultation with one of our experienced immigration attorneys if you would like to discuss your case in more detail. If you have any questions throughout the presentation, please place in the chat box. Excuse me. Today we are fortunate to have our partner, Kelly Weiner, present the webinar. Kelly is a partner with Scott Legal PC, excuse me, and has extensive experience processing the employment-based green cards. So without further ado, we'll get started.
Thank you, Katie. No problem. All right, so we'll go to the first slide. All right, so we're going to talk today primarily about how to obtain an employment-based green card through the PERM process with employment, but we also want to just briefly mention, some of the other categories that you can use to get an employment-based green card. So some of these are, the EB-1A, extraordinary ability. This is an attractive one because you can self-petition. So you can apply with an employer, but you don't necessarily need an employer. There's also the EB-1B, the outstanding researcher professor for people who are coming to the United States to work in academia. There's the EB-1C, multinational manager or executive. So many times people who are maybe on an L visa and had a managerial or executive, job abroad are coming to, kind of continue that work and, would be eligible for the EB-1C. There's the EB-2. So this is, as a threshold matter, you have to have either an advanced degree or exceptional ability, which is a lower standard than the EB-1A extraordinary ability. And there's 2 ways to apply under the EB-2 category. One is the National Interest Waiver. That is where you ask them to waive the normal requirement of the labor market test and the job offer. Because you are working in an area that has substantial merit and national importance to the U.S., you're well positioned to advance that endeavor. And on balance, it's beneficial to the U.S. to waive the normal labor market test requirement. We do have kind of separate webinars that go over the EB-1A extraordinary ability, EB-1C, and also the national interest waiver. So these can be kind of good options, depending on your circumstances. The other way to get the EB-2 is through the PERM. So that is the company sponsorship process. There's the EB-3. This is, again, through the company sponsorship process. So a U.S. employer is going to sponsor you to get your green card. The categories here are professionals. That means any job that requires at least a U.S. bachelor's degree or higher. And then skilled workers, at least 2 years of education, training, or experience required for the job, or unskilled workers, which is anything below that. And there's a more limited number of employment-based green cards for the unskilled workers category. There's also EB-4. This is kind of a variety of special immigrant categories, for example, like religious workers. We won't really talk about that. And EB-5, which is based on investment and creation of U.S. jobs. This is where you're going to invest either $800,000 or $1,050,000 into a new commercial enterprise, and you'll need to sustain that investment and show you've created at least 10 full-time jobs. And this is kind of an investment green card, and kind of is a more longer dated green card in terms of the amount of years it would take to finally get your 10-year green card. Right. So let's talk a little bit more about the EB-2 and the EB-3 and the labor certification process, and what is the PERM. So in terms of EB-2 versus EB-3, we went over a little bit of this in the last slide, but EB-2 is for applicants where the job requires either an advanced degree, which means a U.S. master's degree or higher, or its equivalent, which is a U.S. bachelor's plus 5 years of progressive post-baccalaureate work experience, or exceptional ability, which is showing that you meet 3 out of 7 criteria. The EB-3 is for, again, professionals, skilled or unskilled workers. So and it's based on kind of what the job requires. So if you are someone who has a master's degree, but the job you're being sponsored for only requires 2 years of experience, you're not going to be able to qualify under EB-2. So it is based on both what the applicant has in their own background, but also what does the actual U.S. job require. So the PERM is a company sponsorship process, and there's 3 steps to this. The first one, kind of the longest one, is the actual PERM. This is filed with the U.S. Department of Labor as opposed to U.S. Citizenship and Immigration Services, and we'll go over each of those steps for the PERM. And then there's the I-140, which is the second step. That's where the employer is going to file a petition with U.S. Citizenship and Immigration Services saying that they want to sponsor this worker for this job. And then finally, the I-485 or consular processing, that's the actual green card step. And you don't get there until kind of the end of the process. So let's talk about the PERM. The first step when you are doing a PERM is to draft a PERM compliant job description. And this means that you're asking for the minimum requirements to do the job in a reasonable manner. And the government requires this because they want the job to be open to U.S. workers. The purpose of this process is for them to say to the employer, if you want to hire somebody who is not a U.S. worker, you have to first prove to us there are not any U.S. workers in the U.S. labor market who are willing, qualified, and available to do this job. That means that job descriptions that most employers draft, which are, often aspirational or ask for, bachelor's required, master's preferred, or, great communicator, maybe some very subjective soft skills that they want. Those can't be included in the job description for a PERM because, again, you have to think about if I had to hire somebody off the street tomorrow for this job, what is the absolute minimum requirements they would need to do the job in a reasonable manner? And then the employer has to be in a position to kind of defend that. So the employer may start out thinking, well, I want a master's and 15 years of experience. But very often it's hard to justify that that is actually the minimum requirement to do the job in a reasonable manner. And so you have to kind of, strategically work to say, what are the minimum requirements? And then also, what does the employee have in their own background? Because you can't ask for any requirements that the employee themselves doesn't have or didn't have before they joined your company. So once you have the job description drafted, then you're going to submit that to the Department of Labor and ask for them to provide you a prevailing wage determination. And this is a determination that they make to say this is the minimum wage that has to be paid when the person, gets the job in the future. And this is based on the location of the job requirements, the job duties, the ONET occupation code of the job. And once you get the prevailing wage, the employer has to look at that and say, yes, we are, able to pay this in the future when they get the green card, or if it's too high, you may need to refile. But that's the next step of the process. And it takes about 6 months to get a prevailing wage determination back from the Department of Labor. Once you have that determination back, then you can start the recruitment process. And this is the actual labor market test. So this is where the employer is going to have to place advertisements. If it's a skilled workers or unskilled workers position, you only have to place, 3 mandatory advertisements. If it is a professional position or, advanced degree position, then you have to include 3 additional mechanisms of advertisements. So there's a very kind of strict regulatory way that you have to do the advertisement. It's not kind of a normal recruitment process the employer might do. There's specific places they have to post, and then they have to, have proof that they've posted, and they have to post for certain lengths of time. For example, you always have to post at least a 30-day job order in the state workforce agency where you're recruiting for the position. 2 postings in the news, Sunday postings in the newspaper of general circulation, or a professional journal sometimes. and then a notice of filing at the actual place, physical place of employment to alert the other employees that a PERM process is underway and allow them to apply for the job if they want. And then there's a list of 10 other options for people that have to also post 3 additional advertisement mechanisms. So this recruitment process generally takes at least 2 months because you have kind of 30 days where you're posting most of the ads, and then kind of the 30-day, what we call quiet period, where the ads may not be running, or maybe only one ad is running, but the employer still has to be interviewing anybody who applied for the job. Once you get to the end of that time frame, then if the employer has not found any willing, qualified, and available U.S. workers for the job, they're able to proceed with filing the labor certification. If they have found U.S. workers who are willing, qualified, and available, then you're not able to proceed with the PERM process at that time because essentially the employer has tested the labor market, found that there are U.S. workers who would meet this criteria, and therefore they cannot proceed with hiring the foreign national, through the PERM process right now. A common misconception employers sometimes have is that they have to hire some of the people in this labor market test, and that's not the case. So they are not required to hire anybody. But if they do find somebody that they cannot fairly eliminate, they're because they are willing, qualified, and available for the job. They just cannot proceed with the perm at that time. They may pause and kind of test the labor market at a later time, but the process would have to stop if you did find a U.S. worker, although you don't have to hire them. Assuming that you can file your labor certification, right now the labor certifications are taking about 18 months to be processed, and they can be approved, which is also called certified. They can be denied or they can be audited. So if they're audited, what that means is that the Department of Labor wants to see the proof that you conducted the labor market test in the way that they asked you to. They want to see proof of the resumes of the people that applied, maybe the evaluation sheets the employer filled out explaining why this person wasn't willing, qualified, and available. And if you have an audit, you have 30 days to respond to it. And then they'll usually issue a final decision after that. So this whole process of the first step of the perm can be quite long because if you're, 6 months just to get the prevailing wage, 18 months once you file the labor certification to get a response, that in itself is already taking you up to 2 years. And that's just processing times. That's not including the time needed to refine the job description, the time needed to do the labor market test. So when you're planning for a perm, you do need to plan well in advance and think about if the employee is going to have any gaps in employment, or can you switch them to other, visas? Is it okay if they leave the US for some time? So you want to be planning all of this as you're doing your perm. Um, all right. So once you've gotten your perm certified, that very long, process that required a lot of work on the part of the employer, now you are at the I-140 stage. And this is the one step of the perm process where you're actually able to use premium processing and get a faster response. So if your perm is certified, it'll be valid for 6 months. During that 6-month validity period, you need to file your I-140. That's going to be filed by the employer, and the employer will include the proof that they have the ability to pay that offered wage, at least the prevailing wage. Sometimes it's higher. So they have to provide tax returns, showing they have either the income or net current assets equal to or greater than the wage. There's supplementary evidence you can include sometimes. For example, if the employee is already working for you, making that wage, you can include their W-2. If the company has over 100 workers, sometimes you can include a letter from a CFO as opposed to including the financials if the company doesn't want to provide that. Then you also have to include proof that the employee meets all the requirements in the labor certification. So if the job required a bachelor's degree and 2 years of experience in finance, your I-140 needs to be submitted with proof of the employee's bachelor's degree, transcripts, and employer experience letters showing that they gained that experience before they joined the perm employer. And so for this one, the I-140 processing times are several months, but you can pay an additional fee to get a response within 15 business days. This can be an approval, denial, or request for more evidence. If it's a request for more evidence, you would submit the evidence and then they'll issue a final decision, generally, 15 business days after that. Now we're at the third step. So this is the green card step. Sometimes you can concurrently file the I-140 and the I-485 together if the category is current or the priority date, allows you to do that based on the visa bulletin. Sometimes you're not in a position to do that. Sometimes there's backlogs generally for EB-2 and EB-3, although for this month, EB-2 is current again, which it hasn't been for quite some time. Um, so you actually can file concurrently this month in March 2026. But again, that hasn't been the case for some time. So, it also depends on kind of what status you're in, right? So if you are not currently in the United States, the PERM is for a future job. So if you're not working for the employer yet, the I-485 may not be available to you. But if you're in the U.S. working for the employer, which is like the normal, way that things go, then you can file the I-485. The benefit here is that you can stay in the United States. You can also file for your family members, your spouse, and any unmarried, children under 21. They can apply for work and travel authorization along with the I-485. Um, the other option to get the green card is to go through something called consular processing. And this is a process that happens outside the United States. So let's say that maybe you're on an E-2 visa and you don't want to file the I-485 because once you file it, you won't be able to travel internationally. At that point, you may decide consular processing is better for you. And that's where you are going to apply at a consulate abroad. And I think we'll go into more detail about that in the presentation. All right, so let's talk a little bit more about the green card step. So this is, again, the last step of the process, and there's two ways to go about this. So one is to file the I-485 with U.S. Citizenship and Immigration Services. For many people undergoing the PERM process, this is going to be, the more common route because usually if a U.S. employer is going to sponsor you for a green card, it's because you are already working for them. That's kind of the most common scenario. And if you're doing that and you're living in the United States and your kids go to school here and your, spouse works here, the I-485 does give you, kind of that benefit of being able to remain in the United States while the application is pending to work, to apply for travel authorization. And then at the end, most applicants will have an interview with the USCIS officer where they'll ask questions about the job. It's also sometimes possible to be approved just on the paperwork, but that's happening kind of less and less. If you are approved, then after the interview, your green card will be mailed to you, usually within 1 to 2 months. The other option is this consular processing option. And again, like this is something that for people who maybe are on a status that's like not an H&L and they don't have, several months to wait for the travel authorization to be granted. For example, people on an E, people on an O, they may prefer to go through consular processing. This can also be available if, let's say, you were on a visa status and you ran out of time, you were on an L or what have you, you couldn't switch to another visa status, and you're outside the United States and not currently working for the employer in the US, then consular processing is the route that you would follow. And the way that this works is that once your I-140 is approved and the priority date is current, the approval is sent to the National Visa Center, and then they will send a welcome email. Then you'll fill out something called a DS-160. You'll send a lot of supporting documents, passport, marriage certificate, divorce certificate, police certificates. All this will be sent to the National Visa Center and they will review the documents. They usually take, maybe 8 to 12 weeks to review. Uh, Once they are done with their review, your case becomes what's called documentarily qualified. And then it gets sent to the US consulate, either where you're living or in the last country you were living in before you came to the United States. And then you'll kind of go through the process with the consulate to interview and get your green card. It can take some time to get an appointment at the consulate. Consulates have very wide range of kind of backlog and delay. So it is important before you decide to go through consular processing, if you do have a choice, you want to understand how long is the delay at the consulate where I will be processing, because you don't have the choice to just pick any consulate, right? So it's the consulate where you're a citizen of that country or where you have the residency and you are residing or were residing before you moved to the United States. Um, You'll have to attend a panel for either of these. You'll have to attend a medical exam. You don't get to choose the doctor. The doctor, with USCIS, they have a list of kind of doctors that you can choose from. If you're doing a consular filing, they usually have what are called panel physicians who are selected by the consulate. So you'll need to make an appointment with one of them. They will mail the medical exam directly to the consulate. You'll attend an interview with the consulate. And if you are approved, you'll get an immigrant visa stamp in your passport that is valid for 6 months. You'll enter the US while it's valid. You'll get it stamped in and entered as a legal permanent resident. And then your green card will be mailed to you, usually within a couple months after you enter the United States. Okay, so who can pay for the green card fees? This is a very common question. And fees related to the PERM process, both legal fees and other fees, like the fees paid to place the advertisements, have to be paid by the sponsoring employer. And the reason is that they do not want, employees coming to their employer and saying, "Hey, will you sponsor me for a green card? I'll pay for everything." They really want this to be an employer-led process where the employer is deciding we need to sponsor this person because we really need them, for this company. However, once you get to the I-140 stage of the process, the I-140 petition and the green card fees and the dependent fees, those can be paid by either the employer or employee. So there's a little bit more flexibility there. All right, let's talk about dual intent. So when you're going through the green card process, it's important to understand, if you're in the U.S., what is my underlying visa status and what kind of intent does it require? So many non-immigrant visas do not allow for dual intent. So this means that in order to qualify for the visa, you have to show that you do not intend to move to the United States permanently. Things like the F1 visa, the TN visa, there's a requirement that you have a residence in your home country you do not intend to abandon. Um, there are visas that have dual intent. The H-1B and the L are the ones that explicitly have dual intent. It's in the regulations. The O is listed here because it's almost sometimes considered like a quasi dual intent visa. There is some language that says just having an immigrant petition pending does not mean that you can't qualify for the visa. However, it's not as favorable as the H-1B and the L, where it's just crystal clear in the regulations that you are allowed to both hold this visa and also have the intent to get the green card and move to the US permanently. So again, you want to think about which visa are you on? For example, if you're on a TN and you want to go through the green card process and your employer is willing to switch you to an H-1B, that could be more favorable for you down the road because once you're on the H-1B, you're allowed to have that dual intent. You're allowed to travel internationally while the adjustment of status is pending. So there's some benefits there that you wouldn't get on the TN. It doesn't mean that being on a TN or if you're not selected in the lottery, the H-1B lottery, it doesn't mean that it is impossible to go through the green card process. You can, but it just means it's riskier, and you want to be more thoughtful about your timing in terms of when you're getting your TN, when you're renewing your TN, what your travel is looking like, and when you're actually making the decision about staying permanently in the US. Right. So considerations when moving from a visa to a green card. So we've kind of been talking about this. We'll continue the conversation. So when you are going through the green card process, you want to think about how much time is left on your current underlying visa, because there are some visas you will not be able to extend or renew, once you file your I-140 or once you file your green card petition. So going back to the example of the TN, that would be one that once you've filed an I-140 petition, it doesn't bar you from trying to renew your TN, but if they see that you have a pending I-140 or an approved I-140, particularly if you've checked the box that you want to adjust your status, they may deny you because they may say, well, you have proof here that you want to, adjust your status and move permanently to the US. Uh, if you've checked consular processing, if you have a very backlog priority date, you can always try to make the argument to the officer that on this particular entry, your intent is temporary, and that if you do have a green card application in the future, which is still kind of speculative because of the long delay, that you will, kind of leave the United States and process that green card process abroad through a consulate. And therefore, for this particular entry, you are still eligible. Some officers will accept that, and still grant the visa. Some will not. Similar kind of calculus, with an F1, again, where you have to show you have this residence abroad you don't intend to abandon. So the ideal scenario is that you have a kind of multi-year, multi-entry visa and that you've renewed it and are not in a position of having to renew it, right after your I-140 is filed. You want to think about, do you want to adjust your status in the US or get the green card through consular processing? If you select consular processing on your I-140 petition, it is relatively easy to then just switch to adjustment of status if you're in the US, because when you're in the US, the process would just be to file the I-485 and then notify the National Visa Center that you don't intend to proceed with their process. If you select adjustment of status and later you want to transfer to a consular processing process, that can be much more complicated. You do have to file a form called an I-824. There's a filing fee. It can take several months, and it can be more of a headache to get the case kind of transferred to the National Visa Center when USCIS adjustment of status was selected. So just something to keep in mind when you're making that decision about which route to go if you're not quite sure. Um, for family, you want to plan ahead. You have children that also need your green card. Consider filing early to avoid any issues with your children aging out at 21, especially because the PERM process is taking so long right now. Even if your child is 19, and you're just starting the PERM process and it takes 18 months just to get a response on the PERM, you're not in a good situation in terms of being able to include your child on your green card application. All right. So most applicants for the green card through employment will have an interview either with USCIS or with a consular officer at the consulate abroad. And here's some things to consider before your interview. So you do want to prepare. Don't just show up without having reviewed all of your documentation. You want to review your immigrant visa petition and your green card petition, whatever portions of it your employer has made available to you. Sometimes they will redact certain financial information. That's fine. The important thing for you is understanding, what is the job, making sure it's consistent with what's in the PERM, making sure that on your green card petition, there's kind of no inadmissibility issues. If you've ever kind of violated your status in the past, like that things have been addressed or that you're eligible for an exception. For example, there's an exception called 245K exceptions for people who maybe have violated their status on previous trips, but haven't done so within the last 180 days since their most recent entry. So very important to discuss all of that with your immigration attorney, before you submit your applications, and then go over all of that before you do your interview, because they are going to look back for a USCIS adjustment of status interview. They are going to look back at your entire immigration history, from every time you kind of visited the United States. They may ask about it. So if you have a very long history in the US or you had a lot of work visas or other visas, you want to make sure that you've reviewed that history in detail and you understand everything, particularly if there was ever any accidental overstays or violations or anything like that. You want to organize and print the documents to bring to the interview. So you're going to bring originals of certain documents like your passport, your marriage and birth certificates, divorce certificates, things like that. You need originals. And then you also want to bring a copy. They should have a copy in their records, but you still want to bring both because it's better to have it and not need it than to need it and not have it. Um, you also need to make sure that your medical exam is completed. So with USCIS, that's going to be on the form I-693. You now have to submit that with your I-485. So for everyone kind of filing now, you should already have submitted it, or usually they'll issue an RFE to get it. But it's now required to submit initially, or they won't even accept the I-485, which is a change from longstanding previous practice. If you're going to the consulate, then generally they have their own procedure where you will need to attend that panel physician interview, and you need to do so with enough time that they're then able to send the results over to the consulate or give them to you to hand deliver to the consulate. You want to get updated proof of your employment from your sponsoring employers. So sometimes with USCIS, this will be an I-485 Supplement J. Sometimes it's just a letter from the employer confirming, yes, we plan to offer them this job at the wage and job duties and location that were outlined in the PERM. If you're in the United States, you want that proof of maintenance of status. So all your prior visas, your I-94s, your travel history, explanations for any accidental violations, if there are any, and then meet with your attorney and do a practice interview. Even if you feel, well, I've done similar types of interviews, or, I know the information, it can be a nerve-wracking experience, and you want to just be prepared, and you really want to make sure that you are kind of sitting down and preparing for this interview because it is quite important. Okay, so what is porting and can you change employers during the PERM process? And this is another very common question. because it is a very long process. And so over these periods of time, people are often, eager to understand if one employer started the perm for me, can I jump to another employer and will I get any benefit from that? And generally, the answer is no. Like if an employer has just started a perm for you and nothing else has happened and you move to another employer, you're really not going to take any benefit from that. However, if you get to the third stage of the process and the I-485 has been pending for at least 180 days, now there is flexibility, and that is through porting. And so at that point, you can port to a new job as long as it is in the same or a similar occupational classification. And the benefit of this stage is that the new employer does not have to do a new perm. They don't have to do a new I-140. They literally can just take it over at the third stage of the process, but they'll have to submit an I-485 Supplement J and documentation proving that the new job being offered, which is now the basis of the green card application, is in the same or a similar occupational classification. So if you went through your whole perm process, to be a finance manager, you cannot, kind of get a new job to be, a bartender. But if it's a new job that is kind of arguably same or similar, you can port at that point in time. So there is that flexibility, but it's much farther along into the process than most people think. So even if your employer's just started the perm or even completed it, if your employer's just filed the I-140, at this point, if you move employers, you're really not taking much benefit. If your I-140 is approved, and kind of approved for a period of time, then you can take the benefit of that priority date to kind of future perm applications, but your new employer will still have to file a perm. So it's only at this late stage of the process, if an I-485 has been pending for at least 180 days, that you actually get that flexibility. All right. So changing employers after obtaining the green card. Again, it's a very long process. Sometimes people, would like to change employers, but stay with their current employer because, not another employer may not be willing to do the green card process. And so a common question is, once I do get my green card, do I have to stay with my, sponsoring employer? So once you have your green card, you're, a lawful permanent resident and you can live and work anywhere. You're not technically required to stay with your sponsoring employer. That being said, when you submit your application, you are making a good faith attestation, and so is the employer, that you intend to work permanently in this role. So if you get your green card and you quit the next day, that's something that down the road, if you apply for other benefits, like you apply to naturalize or become a US citizen, they may look at that and they may have questions about whether or not there was any fraud or misrepresentation in your initial application. That means that it's a good idea to stay with your sponsoring employer for some amount of time. And if you do leave quickly, it's a good idea for there to be some reasonable explanation. For example, maybe your spouse got a better job in another state. Maybe you got a really amazing, offer that you couldn't turn down. So you do want to think about staying with the employer for at least a period of months, if not longer. And if you do leave in that short time frame, and you do plan to kind of file for naturalization in the future, just be sure that you can explain why it is that you left, and that at the time of the interview, you actually did have that intention to continue working for the sponsoring employer. All right,
Okay,
so we've reached the end of the
thank you.
presentation. I know, Katie, your voice is
Sorry.
no, no, you're fine. So it just
I don't see any questions in the
yeah, I
chat
don't either.
box.
So I think we can close here. Thank you everyone for attending. I hope you have a wonderful day.
Thank you.